Hello everyone, welcome to Administrative Law Lectures. In this video, we are going to discuss administrative law, its evolution, causes, definitions, and scope. Administrative law is the body of law that governs the activities of administrative agencies of the government. So let's first understand what are the activities of administrative agencies. Administrative agencies can be shortly classified into three: the legislative, the executive, and the judiciary. All the administrative activities can be covered under these three main heads. So the activities of administrative agencies comprises legislation, execution, and adjudication. Administrative agencies can make rules or legislate when delegated to them by the legislature as and when the need be. They can execute or implement or enforce public policy. They can adjudicate or pronounce decisions while giving judgments on certain matters. These duties, powers, and also the manner in which these powers are executed are governed by administrative law. The concept of administrative law is founded on the following principles. Power is conferred on the administration by law. In welfare state, the scope of activities of the government have expanded. Today, the state is the protector, provider, entrepreneur, regulator, and arbiter. So rule-making power and an authority to decide are described as effective and powerful weapons of administration. So without these discretionary powers on the administrative authorities, there cannot be sound administration. But no power is absolute or uncontrolled, howsoever broad the nature of the power might be. All powers have two inherent characters. First, they are not absolute or unfettered. Second, they are likely to be abused. It is said that powers tends to corrupt, and absolute power corrupts absolutely. So administrative law attempts to control the powers of the government and its agencies so that the discretionary powers may not be turned into arbitrary powers. So there should be a reasonable restrictions on exercise of such powers depending on the situation. Administrative law developed to restrict the arbitrary exercise of powers by subordinating it to a well-defined law to ensure that rule of law prevails despite the presence of discretionary powers vested in the administrators. As administrative law is based on the concept of rule of law, it supports natural justice to adjudicate based on impartiality, unjustness, and prescribed laws and legal methods while serving the people and deciding cases brought before its tribunals. Administrative law provides an effective mechanism and adequate protection to ensure that the administrative or public authorities works in a legal, reasonable and efficient manner. It helps to bring a balance between two conflicting forces, that is individual rights and public interest. Evolution. Administrative law in India can be traced back to ancient history times. The Maurya and the Gupta dynasties of ancient India had a centralized administrative system. Following this, the medieval India, for example, Mughal Empire, had somewhat similar administrative system. There was unified administration. The Emperor Akbar established a form of delegated government in which the provincial governors were personally responsible to him for the quality of government in their entire territory. The kings in the anterior period of history were majorly concerned about three things: protecting the state from external aggression, maintaining law and order, and collecting taxes. Though we cannot ignore effective Mughal administrative policy to regulate trade, extensive road links, manufacturing industries, and agriculture. That's why the Indian economy was large and prosperous under the Mughal Empire. By 1700, the GDP of Mughal India was the largest in the world, leader in manufacturing up till 18th century. Also, the real wages and living standards in 18th century Mughal Bengal and South India were higher than in Britain, which in turn had the highest living standards. British India. With the arrival of the British in India, there was the advent of modern administrative law. Establishment of East India Company increased the government's powers manifold. Several acts, legislations, and statutes were brought by the British Parliament for regulating public safety, health, morality, transport, and labor relations. Delegated legislation was accepted as legitimate power of the executive in Northern Indian Canal and Drainage Act 1873 and Opium Act of 1878. In many statutes, provisions were made vis-a-vis granting of permits and licenses and settlement of disputes by administrative authorities and tribunals. During the Second World War, the executive powers increased manifold by virtue of Defence of India Act. In addition to this, the government issued many orders and ordinances covering several matters by way of administrative instructions. Post-independence. After independence, India adopted a welfare state approach, which in turn increased state activities. With increase in the power and activities of the government and the administrative authorities, the need for the rule of law and judicial review of state actions also increased. The philosophy of the welfare state is specifically embodied in the Constitution of India. In the Constitution itself, provisions were made to secure to all citizens social, economic, and political justice, equality of status and opportunity. The ownership and control of material resources of the society should be so distributed as best to subserve the common good. For better administration and execution of laws at the ground level, procedures such as laying and delegated legislation were borrowed from contemporary regimes and customized to cater to the Indian needs. Also, if rules, regulations, and orders passed by the administrative authorities were found to be beyond their legislative powers, then Such orders, rules, and regulations were to be declared ultra vires, unconstitutional, illegal, and void. This flexibility of administrative law also marks an important feature of evolution of administrative law in India. We can understand better when we discuss reasons for the growth of administrative law in the next slide. Causes and the reasons for growth of administrative law. The concept of a welfare state. As the states changed their nature from laissez-faire to that of a welfare state, government activities increased and thus the need to regulate the same. Thus, this branch of law developed. The inadequacy of legislature. The legislature has no time to legislate upon the day-to-day ever-changing needs of the society. Even if it does, the lengthy and time-taking legislating procedure would render the rule so legislated of no use, as the needs would have changed by the time the rule is implemented. Thus, the executive is given the power to legislate and use its discretionary powers. Consequently, when powers are given, there arises a need to regulate the same. The inefficiency of judiciary. The judicial procedure of adjudicating matters is very slow, costly, complex, and formal. Furthermore, there are so many cases already lined up that speedy disposal of suits is not possible, even for very important matters. Hence, the need for the tribunals arose. Scope for the experiment. As administrative law is not a codified law, there is a scope of modifying it as per the requirement of the state machinery. Hence, it is more flexible. The rigid legislating procedures need not be followed again and again. Definitions of administrative law. Ivor Jennings has defined administrative law as the law relating to the administration. It determines the organization, powers, and duties of the administrative authorities. This is the most widely accepted definition of administrative law. According to Wade, administrative law is the law relating to the control of governmental power. According to him, the primary object of administrative law is to keep powers of the government within their legal bounds so as to protect the citizens against their abuse. According to Casey Davis, administrative law is the law concerning the powers and procedures of administrative agencies, including specially the law governing judicial review of administrative action. Garner also adopts the approach advocated by Casey Davis. These are some definitions of administrative law given by different jurists. Scope of administrative law. Administrative law is a branch of public law, which means that it deals with the relationship of individuals with the government. The boundaries of administrative law extends only when administrative agencies and public officials exercise statutory or public powers, or when performing public duties or public functions, not when performing private functions. For example, if a citizen works in a state-owned factory and is dismissed, he or she would sue as a private law function. However, if he or she is a civil servant, he or she would sue as a public law function. Similarly, if residents of the surrounding community were concerned about a decision to enlarge the state owned factory because of the environmental pollution, the legality of the decision could be reviewed by the courts as a public law function. The point here is that the rules and the principles of administrative law are applicable in a relationship between citizens and the state. They do not extend to cases where the nature of the relationship is characterized by a private law functions. Procedures. Many of the definitions of the and the approaches to administrative law are limited to procedural aspects of the subject. It is primarily concerned with the official actions and the procedures and puts in place a control mechanism by which administrative agencies stay within bounds. Hence, to a wider extent, the study of administrative law has been limited to analyzing the manner in which matters move through an agency rather than the wisdom of the matters themselves. With respect to judicial review, the basic question asked is not whether a particular decision is right or whether the judge or the minister or officials have come to a different decision. The questions are what is the legal limit of power or a reasonable limit of discretion the law has conferred on the official, whether the power has been exceeded or otherwise unlawfully exercised. Therefore, administrative law is not concerned with the merits of the decision, but with the decision making process. Conclusion. Administrative law is the law governing the executive to regulate its functioning and to protect the common citizenry from any abuse of power exercised by the executive or any of its instrumentalities. It is a new branch of law which has evolved with time and shall continue to evolve as per the changing needs of the society. The aim of administrative law is not to take away the discretionary powers of the executive but to bring them in consonance with the rule of law. Thank you for watching this video on administrative law.